This is Judge David Fleischer,
Let's roll, nerds.
currently serving on the Harris County Criminal Court in Texas. In recent times, he has been going viral for his honest upholding of justice with an atypical take on your standard operation of a courtroom.
We don't know how many, we don't know how much, we don't know when it was happening.
Well, Judge, I don't think that's necessary.
Today's first case has Judge Fleischer hearing out a case of a major car crash in Harris County with the defendant suspected of being under the influence. But that's all about to change.
Good morning, Mr. McGaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mireles picked up a new case.
Yeah, and he came in, checked in and left saying he had other places to go.
What?
I warned him that if he left, that more than likely a warrant will be issued for his arrest.
Next time,
I can't because I'm on that technical. That's part of the problem.
all right.
But I agree.
Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it.
Okay. October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything
odor.
else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor
Yeah.
was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking. He's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand,
It's just
I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right, no, I'm gonna find no probable cause, Mr. McGaskey. It's very possible if they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm gonna find no probable cause. Just take a seat for a moment. Thank you, Mr. Jeff.
The judge's outcome of no probable cause may come as a shock for some, but after watching the upcoming cases, you will undoubtedly start to see a pattern among the lack of much-needed questioning conducted by the numerous charging officers.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
The following case has Judge Fleischer shaking his head at how pathetic these quota-meeting police officers are.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding,
For speeding, yes.
then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Dems, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, I just an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no. Is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know,
But
Procedure for
right, I get the
SFSTs,
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough.
see what
An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm gonna find no probable cause.
Yes, Judge.
Thanks, Rich.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat.
And here we are again. The case is dismissed due to the officer's insufficient due diligence, as the judge states 2 beers can dissipate at an average rate of 1 standard drink per hour. Just because it can be smelled on an individual doesn't mean it's accurate.
Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
Moving away from DUIs for now, we have a case of Keon Shaw fleeing from police, looking at a sentencing of up to 6 months in jail and/or $2,000 fine. Little does the following man know: Judge Fleischer takes no crap.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
With the officer, he was originally traveling at an unsafe speed exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then,
Nothing's unsafe to me.
and then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You know,
I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius, you know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
terms.
let's do this. I'm gonna have them, because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Don't leave, Mr. Shaw. Okay, who's next?
Just like that, another unjust arrest made right by an unbiased judge who believes if it wasn't added to the officer report, then it shouldn't be able to be used as ammo against them in court.
So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public.
Judge Fleischer seems to deal with lots of DUI cases, but the following case may have you questioning if all of these decisions are for justice, or is it a snub to the lack of caution exercised by the officers involved in these very same cases.
Good morning, sir. Good morning. Sir, you were charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like,
He,
yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
oh, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says
reports.
400
My
block of West
goodness.
Gray Street is a public street.
I mean, I need more information. I mean, does it say he's on the street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, doesn't, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious, but in regards to the location aspect of it, there's nothing further stated on that.
I'm sorry, I'm gonna find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm gonna find no probable cause.
We're on the fence with this one. While Judge Fleischer does make a good point with the officer report not giving enough detail, this man was found in the driver's seat and did blow point 179, which is over Texas's 0.08 BAC limit. What do you think should have happened here? Let us know in the comments below.
Who's writing the reports? Mickey Mouse?
Clearly fed up with the continuously poorly conducted investigations, this judge really lets the prosecutor have it in this explosive moment.
Good morning, Mr. Gonzalez. Do you speak English?
Yes, sir.
Good morning.
Morning.
You're charged with two cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
What was he doing wrong? Oh, you said he matched a call slip. So
Yes, for a criminal mischief in progress, Your Honor.
that's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I haven't heard anything. I'm gonna find no probable cause. Mr. Gonzalez, be careful, man. When you get into a pissing match with people who have the power of arrest, who's gonna win?
I'm gonna be more careful. I promise. It's not gonna happen no more.
Be
I
careful.
promise. I got my family. I wanna,
Okay?
Thank you.
Got it.
God bless you.
Some may call the judge's behavior unprofessional. However, he's not wrong for making the decision ruling no probable cause. Mr. Gonzalez was arrested for matching a description of a perpetrator of a crime he didn't commit. Now watch as Judge Fleischer delivers a jaw-dropping takedown of these corrupt cops who arrested a man just for charging his phone. Yep, you heard that right. He is in court for theft of a service.
Okay,
I wanted to see if we could get a PC for Samuel Duto.
okay, sure.
We are on September 13th.
Okay, hold on. It's just way too loud. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
Okay,
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven. And the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under penal code.
oh, come on. They charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the,
I know, but that's the contact to get to him.
yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so they go up to him, they start talking to him,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he stated his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
Defendant had outstanding warrants and was placed in custody.
They was.
He was charging his phone when he
what do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Do we need help back there?
It's like an adult, and I can treat you better.
You all right back there?
Yeah, he's fine. He's just upset because he wants to go now. He's not getting his way.
Who is it?
I don't even know him. The attorney told him he was done, but I don't know about it.
Okay.
Tyler?
Probably. No, it's not. Let me see.
Talk to Pavel, let's see.
Judge, we'll defer to the court.
All right.
He didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft. So,
When he's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest. I mean, that's.
do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
Because it might happen anyways.
I
You know
wanted
what I mean?
time served. I wanted the time served. He offered, he would have had to do 24 more days.
I'm okay with that, or I'm okay with whatever you want. It's up to you guys.
Yes, Your Honor. I'll always defer to Pavel with things. After 90 days, depends once time served.
Okay, and I'm totally fine with that too.
Okay, thank you.
All right, thank you.
We'll get him up. Thank you.
Hey, Alan. Okay, so first we have, is this that's Rivera and Soto?
With the D.
Oh,
I
Duarte,
can't- I know
right.
I mispronounced it, so. Pronounce it one more time.
Yuto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the.
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it, you know? Most times people plead to the theft case and it really hoses them. Because then you're looking at, you know, not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served. What time are we looking at? No, Roy Duato.
Oh, 18-6.
18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering into these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs so you won't owe anything, and good luck to you guys. All right.
All right, John, we'll go ahead and go right through that door for me.
This plea could raise some eyebrows, as technically failure to ID could be seen as a secondary offense, and since the charge of theft was dismissed, should the failure to ID charge also be dismissed? A bit of a tricky one there, as he did have some outstanding warrants, which could give the officer grounds for an arrest anyways. Let us know your thoughts on this matter in the comments below. We'd love to hear your opinion. As always, thanks for watching. If you liked this video and would like to see more courtroom content, let us know by giving it a like and subscribe.